Hi, I'm Rob Cohen from Davis Polk, and my one big thing is whether the SEC will file any accounting cases relating to the coronavirus. The SEC always is looking for accounting and disclosure cases, and COVID-19 has had a major impact on the financial condition of many American companies. I expect the SEC will be looking to see whether any companies misstate their financial condition in light of the pandemic, or whether any companies make material misstatements about the way they are responding to the crisis. Thanks.
Welcome back. Our next panel is a must at all of the securities enforcement forums. It's on insider trading, a topic that really never gets old and just keeps evolving and developing and twisting every which way. And to the fact that, to the point that there are now very real calls for legislation that would further change the insider trading landscape, and we'll get into all of that. And who better to moderate this panel than Russ Ryan? Russ is uniquely qualified, having served as both an assistant director in SEC Enforcement Headquarters in D.C. and as deputy director of enforcement at FINRA. Russ is a real thought leader in the securities enforcement field. If you read the Wall Street Journal or the Washington Post or any of those business sections, you've probably seen his editorials on various enforcement-related topics. Very thoughtful, and always has an interesting angle on these things. Welcome, Russ.
Thanks, Bruce, and thanks for that introduction, and thank you for having me.
You're welcome. Thank you. Just 3 years ago, Rob Cohen was the keynote speaker at this conference when he led the SEC Cyber Unit. Before that, Rob was co-chief of the Market Abuse Unit. Now Rob's a partner at Davis Polk, where he focuses on representing companies, boards, and individuals in regulatory matters and internal investigations. Very lucky to have Rob with us here today. Welcome, Rob.
Thanks, Bruce. Great to be here.
Our next panelist is Sean Prosser, who began his legal career in the Division of Enforcement. Excuse me. Sean's now a member of Mintz-Levin in their securities, white collar, and litigation practice, with decades of success before the SEC and many other state and federal enforcement agencies. You can try to go through the highlights of Sean's record. It'll take you a long, long time and will not do it justice. Sean, welcome and glad to have you back.
Thank you, Bruce. Really appreciate it. It's fun to be here.
Thank you. And finally, our next panelist is from the SEC is Kate Zolodz, who, as Associate Regional Director, oversees the SEC's LA office enforcement efforts in Southern California, Arizona, Hawaii, Nevada. She started off as a staff attorney in 2010 and then spent time in the asset management unit. She's continued her rise through the SEC ranks with a recent promotion to Associate Regional Director for Enforcement in the LA office, where she succeeded John Barry, who we just saw on the last panel. It's great to have Kate with us here today to hear her perspective. Welcome, Kate.
Thank you so much, Bruce. Great to be here.
Thank you, panel. I'm going to turn it over to Russ.
Thanks again, Bruce, and welcome everyone to this year's Insider Trading panel at the conference. I'm going to, before we start, going to invite people to put questions in the question box on your screen. We'll try to get to as many of them as we can. I'll be checking it throughout the panel. But as Bruce mentioned, there have been a lot of interesting developments in the area of insider trading over the past year. We're going to try to get to as many as we can. But let's get started with Kate. And Kate, can you provide us with a brief overview of what the SEC's been up to in the insider trading area in the past year and any trends you think we should be looking out for?
Certainly. Before I get started, though, I have to give the standard disclaimer that the views that I express today are my own and do not necessarily reflect the views of the Commission or its staff. So with that out of the way, so fiscal year 2019 was a big year. Insider trading cases accounted for 6% of the division's 526 standalone cases, and that included actions against 42 individuals who allegedly misappropriated or traded unlawfully on material non-public information. But the numbers don't tell the whole story. For example, and we'll get into this more later, those numbers don't include individuals who were charged as part of hacking cases. We haven't always included those because they involve a slightly different legal theory. So there are additional actions that would be included there. In terms of trends, I think as in years past in the area of insider trading, the SEC is focused on complex insider trading schemes. So that would be schemes involving multiple traders or multiple events. Just to give kind of a couple examples of those from recent months, certainly the Edgar hacking case, which is getting a little bit older now, from January 2019, and we'll talk a little bit about that later. But a couple recent examples in the Nolor case, and that's out of the Northern District of California. It was filed in December of 2019. In that case, a former IT administrator at Palo Alto Networks used his credentials and contacts to obtain information in quarterly earnings. He tipped 4 of his friends who also traded. So another example, again, of complex insider trading schemes would be the Taylor matter that we brought in October of 2019. This involved a couple investment bankers who were working out of London who obtained non-public information for at least 15 potential acquisitions or tender offers. So I think those are just a couple examples of kind of the complex schemes that we're focused on. Also, in terms of other trends, I think these cases and others are good examples of the use of data analytics tools by the SEC to both find and develop cases. I think that's something that you're going to see more of. Also, a number of our cases, as you know, involve parallel criminal investigations. So one final development I wanted to note, and I think Steve mentioned this as well in his remarks, on March 23rd, the Enforcement Division co-directors addressed insider trading specifically in light of the ongoing pandemic. So I think that's an area that we can watch going forward.
Okay, thanks, Kate. Sean, that's a good segue into, we are in interesting times with this pandemic still upon us. And with it, not just Steve and Stephanie, but others have raised concerns particularly about insider trading in this type of environment. Although Steve and Stephanie didn't get into too much detail on that, maybe you can talk a little bit about the concerns you see and what advice you're giving to clients in that respect.
Sure, thanks, Russ. It's interesting. The SEC's talked a lot, and I'm sure today everyone has talked a lot about disclosure and disclosure obligations and things that companies should be doing. But insider trading is a particular risk that companies need to keep their eye on as well, just because they don't want to get embroiled of their employees, officers, directors, either trading or tipping. So I think it's a time for real re-education and also expansion of the education, because the types of activities that are now going on with the pandemic are different than your typical 8K events. There may be material things going on that are not going to trigger an 8K filing. You may be waiting to your next queue. Those things might be leases or contracts that are being breached. There may be some bankruptcy discussion going on. The market is particularly volatile and sensitive, so anything that can kind of get out early is something that someone might be trading on. The SEC's not, that I'm aware of as of 3 p.m. today, brought any insider trading cases specifically related to sort of COVID-related disclosures or decision-making at a company. But I am sure there are a number of investigations going on. And it can be things not as easy as, we're filing for bankruptcy and someone goes out and sells the stock before it gets out. There's a lot of M&A activity and a lot of discussions about M&A. So you've already seen today the Uber Grubhub announcement and what that reaction is. So in this environment, there's going to be a lot of M&A activity because of the depressed market cap and distressed companies. So companies need to expand their education and reminding of people. And you're going to have more people working remotely where you're not able to supervise them as well, or maybe even train them as well. So it's something particularly in-house counsel need to be cognizant of. Another example that's particular to this, it's a risk. Drug development is always something that could be material that someone could trade in advance of news if they somehow are getting test results. But a couple of weeks ago, Gilead had the issue where it was leaked preliminary data related to one of their drugs and testing. Market price spiked and then quickly declined after those those leaks turned out not to be as positive as initially reported. I am sure there were a lot of people trading on that spike, and so I'm sure the SEC is looking, and I have no information that there was a Gilead investigation, but I suspect there's something going on to figure out who was leaking it, who was trading, and I suspect we're going to see a number of cases like that coming out, over the next six months or so.
Kate, I know you can't really talk about pending investigations, and as Sean said, I don't think there have been any actual case filings yet, insider trading cases related to COVID. But can you give us any kind of insight into just generally whether you're seeing this type of thing that people are concerned about, and if so, how extensive it might be?
Sure. So, you're correct that there are no cases that have been filed yet, so I can't really comment on any specific investigations, but, it's certainly something that we are investigating and that we are looking at. And just kind of following up on the co-director statement that we mentioned earlier, they noted a couple specific concerns related to insider trading in this environment. So the particular concerns, and this is very similar to what Sean was just mentioning, insiders may be learning material non-public information that's going to have an even greater value than under normal circumstances. And this is particularly the case when earnings reports or required disclosures are delayed because of COVID. You're going to have a longer time period that you're looking at. And you may have just more people who have access to material non-public information. So it's certainly something that we're looking at. Insiders should definitely be mindful of their duties and know that we're watching and analyzing the data. And there certainly are investigations and will be more investigations into this.
Okay, let's get Rob in here, because I know this is a topic that, Kate, you really can't talk about, but within the past couple of months, we've seen allegations that various U.S. senators sold a lot of stock in various companies, and in one case, at least one case, one company. At least the reports suggest that maybe it was the transactions were timed very fortuitously, just as the coronavirus situation was becoming better known to the public. And Rob, can you just give us a brief overview of the main issues on that and any challenges you see? I know you were involved in a case against a congressman a few years ago that it wasn't the same type of situation, but maybe you've learned some things from that you can share with us.
Yeah, absolutely. I mean, it's certainly interesting to have an investigation for insider trading of a sitting member of Congress. So there's a couple of unique issues that are not insurmountable, but really unique to that circumstance that you don't have in the routine insider trading case. So one is the speech and debate clause. People may remember from law school that the Constitution protects members' activity in what's called the speech and debate clause. And it can have an impact. The most tangible impact it has during the investigation is on information gathering. The case you mentioned that I was involved in, the Chris Collins case, that did not involve allegations about his activity as a member of Congress. It was about his activity as a member of the board of directors of a private company. But nevertheless, in pretrial motions, the defense raised the speech and debate clause and challenged some of the evidence that had been gathered on the grounds that it violated the provision that prohibits the executive branch from interfering with the activities of the legislative branch. And here, where the allegations, at least as reported in the press, involve information that the members of Congress were receiving as part of their daily legislative jobs, I would expect the speech and debate clause would be a significant issue that investigators would have to deal with. Again, it's not insurmountable, but it's not something the government usually has to deal with. The other issue that's interesting is proving materiality. So, none of us know what were in the briefings that have been reported in the news, but those of us who've worked in government, as each of us have, know that government briefings can have a lot of different perspectives. They can be long. They can have a range of scenarios from best case to worst case. So proving that specific information in one of those briefings was material, that can be different than your routine case where there's information about an earnings announcement or a transaction. Again, not to say that it can't be material, but it's a unique challenge, especially because in the normal corporate insider trading case, at some point the information gets released and you can see how the market reacts. And although it's not determinative, the market reaction to news once it's released is a big part of proving it was material. Here, we don't know if that happened, but if it was a briefing with a lot of information and it's hard to pinpoint a moment when the material, allegedly material information was released, there isn't an easy market reaction that the government can point to show that the information was material. So again, all those things could be challenges that the government overcomes, but they're pretty unique to investigating a member of Congress.
Sean, anything from your perspective on this case?
No, I mean, just in general, the idea of the political trading, it is something that has been going on for a decade that people have been concerned about. There have been rumors for years about funds where politicians are having access to trading. I think it's going to heighten the call for a need for some type of a regulation, whether it's a blind trust, selling plans, things like that, to really keep the politicians sort of immune from the claim of insider trading, because they do have so much power and they're involved in so much decision making. I think ultimately, at least this and some of the other things that have happened more recently, there's going to be more of a clamor for some type of a regulation. And I think that's should be in the offing maybe in the next year or two.
Okay. We do have a question that I think is timely here, so I'm gonna read it and throw it out there, probably for Rob or Sean. Should companies consider asking their officers and directors who trade under 10b5-1 plans to cancel those plans and simply close all trading windows if the company is planning to announce a significant change or event in the based on the unique situation we're in right now? Any thoughts on that?
Yeah, that's a really good question. But I mean, from my standpoint as, defense counsel, the goal and the importance of a 10b5 selling plan is it does not change, and if you change your plan, if you cancel it and restart it, you lose the benefits of it long term. So if that plan had been put in place before the crisis, before the events, I would not counsel a company to tell executives to start canceling their plans, because when can they restart? And then there will be arguments that you lose the protections of 10b5-1.
Okay, great. Rob, anything to add on that?
No, I agree with Sean. I think if it's a long-term plan that was put in place before any current issue, it could be a real unnecessary burden on executives to say you can't sell. And then the question is, when can you reopen? If it was a plan that was put in place, the day before something happened, I might think carefully about it, but otherwise, I think Sean's right.
Yeah. All right, let's shift gears a little bit. We actually have now not one, but two pieces of legislation that are in Congress right now that deal with insider trading. And both of them have already passed the House by overwhelming bipartisan majorities. They're both in the Senate now. One deals with defining insider trading generally and codifying it. Another deals with the short time period between an 8K event and the actual filing of the Form 8K. Rob, why don't you start us off with that and give us a little background on that, because with the passage so overwhelmingly, at least it's plausible that one or both of these pieces of legislation would actually see the light of day.
Yeah, and as background, I assume most or all of the audience knows that there is no insider trading statute. Insider trading cases are brought under the general fraud provisions of the securities laws or the criminal laws. And most of what you think of as insider trading law in terms of misappropriation and classical theory and benefit, that's all judge-made. And there have long been calls for clarity that would ideally come from a statute. And within the last several months, I think we've seen more momentum on that than we've seen in years in the laws you mentioned, Russ. So the first bill that passed the House is the Insider Trading Prohibition Act. There's a couple of things that it does or would do if adopted in the Senate that would really change insider trading law. So first, people may know that right now insider trading cases revolve around information being used or conveyed in breach of a duty. And what it means to have a duty, and when somebody has breached a duty, and how do you prove it, that's a lot of what the litigation is about. The statute, the bill, if enacted and passed into a statute, would change that focus somewhat from breach of a duty to information obtained wrongfully. And that's the word that's used in the bill, and that would be the focus of the law if the statute, if the bill passes, information being obtained wrongfully. And there's a series of definitions of what wrongfully means, and there's quite a lot of examples. Theft, bribery, misappropriation. I think my favorite in the statute is espionage. There's conversion, misappropriation, violation of federal law protecting privacy and information on computer systems. And that clearly was intended to address the hacking situation that Kate talked about. Breach of a duty is included in one of these examples, so that's retained as a predicate for insider trading. And the idea of a benefit, which we'll talk about, that was also retained in a last-minute amendment. So that's not done away with, but it would become only one way in which the government could prove that information was obtained wrongfully. The other change the law would make is about downstream people, tippies or traders, and what they knew. So there's a lot of litigation now in both criminal and civil cases about what did the downstream people know. And in particular, what's been litigated a lot recently in the Second Circuit and the Supreme Court is the concept of a benefit. And did these downstream traders who had information passed to them from somebody else, did they know that the information was obtained in breach of a duty, which requires a benefit? So what the bill says about that is that these downstream people would not need to know exactly how the information was obtained wrongfully, and would not need to know if there was a payment of a benefit. They would need to know information was obtained wrongfully in some way, but they would not need to know the specifics.
So it sounds like it wouldn't require a proof of actual fraud. It sounds like.
Yeah, and I think, and it seems that the bill is an effort to broaden this here, because certainly the government spends a lot of time in proving what the downstream tippies knew. And certainly, at least in SEC cases, whether the downstream tippies were reckless, whether they sort of consciously disregarded the likelihood that there was a benefit to the source of the information. And under the bill, that wouldn't be necessary. You would just need to show, it seems, that the downstream people were aware that the information was obtained wrongfully. So I think those are the highlights of that bill. I'll just note that people have probably heard of the Barara report. This is a report put out by a group led by former U.S. Attorney in the Southern District, Preet Bharara. Takes a very similar approach to that bill in emphasizing the importance of information being obtained wrongfully. It goes a bit further, and it would eliminate the required proof of a personal benefit at all. And it would also clarify that there's two different levels of scienter, one for criminal cases, which would have to be willful, and one for civil cases, which can include recklessness. So the Barara bill is pretty similar, but I think it goes even further.
Can you just take a minute or two on the 8K legislation?
Yeah, and I think in some ways the 8K bill would represent an even bigger change, because it would really create a type of liability that doesn't exist today. So most public companies have very good policies and procedures to prevent insiders from committing insider trading. There's blackout periods, and 10b5-1 plans are often required, but those corporate policies are not required by law. The 8K trading gap bill would require the public companies have those types of policies and procedures to prevent trading for the first time. And the bill focuses on a particular issue, which is the period of time between an event happening and the company later filing an 8K about that event. And it would require the SEC to promulgate rules that require companies to have policies and procedures to make sure its people do not, I shouldn't say people, its executive officers and directors do not trade during that trading gap. And so not only would it impose a new requirement on public companies, what's really interesting is it's not limited to material information. So even if the 8K involves something relatively minor and it's not material, the bill is written and is passed in the House would still require companies to prevent their senior people from trading during that time period, even if the information is not material, which would really change the focus of what these policies do today.
Maybe that they can iron that out in conference or in whatever they call it when the Senate deals with it. Kate, you mentioned in your earlier remarks hacking and data breach type cases, and they're not historically considered part of the insider trading docket for statistical purposes. But we've seen some developments in that area. Do you want to just talk about that for a little while?
Sure. Probably most folks are aware, but so the hacking cases do have a slightly different theory of liability. So in a hacking case, you have someone who is obtaining unauthorized access, and they're not actually breaching a fiduciary duty. So neither the classical theory nor the misappropriation theory of insider trading is really going to apply to that type of situation. So rather, the courts have relied on the language of 10b and the deceptive terminology there to say that when a hacker affirmatively misrepresents himself in order to gain access, that's the deceptive conduct that would constitute the violation. So in terms of a couple of noteworthy cases that the SEC has brought in that area, we've mentioned the Edgar hacking case, and I know Rob is intimately familiar with that case as well. But that was brought in January of 2019, and a Ukrainian-based individual who was working with others hacked into the SEC's Edgar filing system to extract test filings of earnings announcements before their public release. And the traders traded before at least 157 earnings releases, generating at least $4.1 million in illegal profits. And what's interesting in that case, too, is that the hacker and some of the traders were involved previously in a scheme to hack into the newswire services. The SEC charged those individuals for that conduct in 2015. Another significant case in that area was brought in December of 2016 and involved some overseas hackers who got into two U.S. law firms to obtain non-public information, and they traded on that for almost $3 million in illegal profits. What I find an interesting kind of takeaway from some of these hacking cases, in particular the Edgar hacking case, is that even when you look at the hackers, the traders having access clearly to inside information, they didn't actually successfully trade 100% of the time on this information. But I think is interesting that even having inside information, you can't always predict how the market's going to react. So we really had to dig into the data to show a pattern over a period of time. Which is a strong basis for our action there, and really shows the sophistication that's needed to bring these types of cases.
Sean, I know you've had some experience in this area too. You got anything to add to Kate's?
Yeah, the SEC Edgar is near and dear to my heart because I have the good fortune of representing the only U.S.-based trader in the case. And it's interesting, the SEC always says the hacker trade and then the trader, and it's sort of like all combined as one. But in the Edgar case, there were the hackers, there were traders in Ukraine and other countries, two traders in the U.S. And even if you look at the SEC's complaint, they lay out how the U.S. traders traded last. They were way after everyone else, not way in days, but minutes or half an hour or 45 minutes or 2 hours later on. And there are a lot of people around the world, and these almost all related to earnings releases. So there are a lot of traders that are always looking at the pre-market activity and looking for really interesting spikes. One day I'll be sharing with the SEC some very interesting charts that will show the type of activity that the U.S. traders would see and would jump on that. There's the allegation, too, that some of the people that traded in the Edgar hack traded in the Business Wire hack in 2015, but some of those people were never charged in 2015. So the SEC is trying to sort of combine the two to say, well, you were part of this other thing, we didn't charge you, and no one criminally came after you, but now you did it again, where there are a lot of mitigating circumstances, and you have situations where traders, trade in their own name, don't take the money and run, sit there trading, believing that they're detecting activity, that activity very well could have been as a result of a leak or a hack of data. But, and I know our colleague here, Rob, will have some thoughts on this, but, the SEC complaint very clearly alleges 6 different places the hackers passed hacked data to the traders. So you get into it, there are no facts indicating that. There is no evidence of data from a hack going to the U.S. traders. It is sort of very remote. So, this case is ongoing. It's exciting. It's very frustrating, but it's very interesting as well.
Rob, are you in a position to respond, or you'd rather not?
Well, I did, along with Joe Sansone and Carolyn Welshans, I did supervise that investigation and the filing of that complaint. So I think I'm going to pass on the opportunity to argue the merits with all respect to both sides of that. I look forward to seeing the litigation in the news.
Yeah, the one thing I'll add to it, it's interesting too, you think about it, if someone is hacking into Edgar and taking that information and trading, wouldn't you think the SEC would have filed a TRO or gone for an injunction, and with any insider trading case, they contact the broker dealers and freeze the accounts. None of those things happened here. No criminal charges, no freeze. And you get a lot of foreign defendants or maybe someone related to the hacker who will either just default or they'll quickly settle. And then you're left with sort of a more remote trader sort of holding the bag and then dealing with the litigation, where the SEC has, that lower burden of proof, the preponderance of evidence, that the criminal people wouldn't bring that case, but the SEC does. And I understand why, and I'm sure the case was brought with the best of intention and expectation that the evidence would bear out what they thought. But unfortunately, at least for our clients, they're facing the litigation and there isn't evidence that they knew what was going on.
John, you're certainly tempting me, but I'm going to resist. I'm going to resist that bait and let you have the only word on that for today.
Well, Rob, going back to the statute you were talking about, the pending bill on insider trading, it sounds like the definition of wrongful conduct was in part designed to make these types of cases fit more squarely into a violation than under the fraud statutes. Is that accurate, or what's your thought on that?
Yeah, no, and there has been commentary about this, including Commissioner Rob Jackson, who's written about this. So going back a number of years, there was a Second Circuit case in an SEC case called Droshko that really is the leading and maybe the only, at least at the circuit court level, opinion on hacking and the securities laws. And it held there that hacking activity can violate the securities laws if it involves deceptive conduct. It's not clear whether it has to include deceptive conduct, if that's the only way to get there, but certainly it outlined a path to get to a violation if the hacking activity involved deceptive conduct. And I think in the cases that have been alleged since then, there have been pleadings of deceptive conduct to meet that standard. I think the bill clearly is intended to eliminate that perspective by focusing on whether information was obtained wrongfully. And as I mentioned, even specifically talking about computer information and computer privacy and information that was obtained wrongfully in breach of any sort of obligation to respect people's privacy on computer systems. It certainly seems that one intent of the bill was to make sure it covers hacking activity regardless of the deceptive element.
That was my perspective. Kate, some of your colleagues, I think it was on the directors panel, talked a little bit about credit for cooperation for individuals as opposed to companies. And I can see that might be particularly relevant in the area of insider trading. Is there anything you can point to that should give us comfort or in terms of whether it's worth it for an individual to cooperate?
I certainly think it's worth it. I think my colleagues on the panel may not always agree with that. So I think it's rare that we see like a true self-report. There are a couple examples of that, a couple recent ones in some settled APs, one from February of 2020, the Kerwin matter, and another one from August 2019, Lorenz-Earn. And in both of those matters, there was a self-report, and we agreed to a halftime penalty in those cases. And in fact, the actions actually came so fast that there wasn't even any prejudgment interest there, and no criminal prosecution. So I think that's really on one end of the spectrum of someone who comes forward and immediately self-reports their conduct, which does happen on occasion. I think the more usual type of cooperation we see is individuals who've been approached either by the SEC or by the criminal authorities. They're not going to get the same types of cooperation credit that someone who self-reports is, but it may result in reduced sanctions or reduced jail time.
Okay. Let's spend a few minutes on a really important Second Circuit case. We've got a couple of questions in the queue too, but a couple of months ago, the Second Circuit upheld a somewhat controversial theory under the criminal code, 18 U.S.C. section 1348. Rob, you want to lead off on that?
Yeah, I'd be happy to, and I'll start with a disclaimer that I supervised this case, and so I'm not going to opine on anything, but we'll happily discuss what's in the public domain.
You supervised it on the SEC side, right? But
correct.
The decision is in a criminal case, but I see where you're going on this. Obviously, we don't expect you to give away any state secrets.
No, it's an excellent point, Russ. There were parallel cases, and as is customary, the criminal case proceeded first to trial, and the Second Circuit decision is in that criminal case. And in fact, that's really what's interesting is the distinction it sets up between criminal and civil. So just a minute on the background, the case focused around an individual who is a political consultant who specialized in information about what the government was doing. And the SEC and the U.S. Attorney's Office of the Southern District of New York alleged that this individual had obtained information from a friend who still worked in the government about what the government planned to do to reimburse certain healthcare procedures, such as dialysis. And these changes in the reimbursement rates allegedly would have a significant impact on a few companies who dominate that business. And so the government alleged that he obtained this information from a friend about these upcoming rate changes and tipped 3 analysts at a hedge fund who then caused the hedge fund to trade. And there were parallel SEC and criminal cases. The criminal case charged the consultant in the middle, the government person, and the analyst at the hedge fund. It went to trial. There were convictions on at least some counts for everybody, but there were a number of counts on which the defendants were acquitted. And on appeal, one of the arguments from the defendants concerned evidence of a personal benefit. And what the Second Circuit held was that under Title 18, which you referenced, personal benefit is not required. So just for a backdrop here, because someone might wonder, why are there 2 different insider trading laws? So Title 15 is what the SEC uses, and the criminal authorities can use it also. Title 18, this provision was adopted in the early 2000s as part of Sarbanes-Oxley, and it also arguably covers insider trading. And so the counts on which there were convictions were under Title 18, this newer criminal statute, not Title 15, which the SEC uses. And as the Second Circuit held that personal benefit is not required under Title 18 because of the court's view of the history of that provision and the intent behind it. And so what it potentially sets up is different elements of insider trading claims under Title 15, which is what the SEC has to use, and Title 18, which the Department of Justice is entitled to use. And the Department of Justice can still use Title 15, but now they seem to have this other option also. So that part of the decision has really generated a great deal of commentary. I believe that a petition to have the court hear it en banc has been denied. And I think the open question is whether the Supreme Court will take it.
Yeah, Sean, you got any prediction on that?
Yeah, because this case sort of came out of nowhere, this type of a distinction. You would hope that Supreme Court would look at it and try to harmonize the two statutes, the Title 15 and Title 18, so you have a consistent treatment, because you have this crazy circumstance where it might be easier to criminally indict someone for insider trading, but the SEC with a lesser standard doesn't bring its case because there's no personal benefit. So you would hope Supreme Court would look at that and try to resolve the question, but it hasn't been addressed by any other circuit. I could easily see the Supreme Court just letting it sit for now and waiting for either legislative action to make a modification to maybe Title 18, or wait for the other circuits to weigh in if this ever does come up again. But if you're defending an insider trader and there's no personal benefit, you think you're in the clear essentially, or not a trader but a tippee or tipper. But now you have a criminal risk where you actually didn't even have an SEC risk. So it's a crazy circumstance.
Yeah, why would the government ever not file it under Title 18? It just does. It seems like if this decision is upheld, it's much easier to convict under Title 18 than the usual insider trading statutes. So, in any event, so I think I agree with you that I'd love to see the Supreme Court take up the case, but I think they may well let this thing percolate in the circuits a little bit more before they step in on that. Kate, this doesn't really directly affect the SEC. I don't know. Do you have any thoughts on, whether it does or whether it might raise some concern, at least, that if it becomes easier to file criminal insider trading cases than civil ones, the SEC might lose its sort of historical ownership of of insider trading enforcement anyway. Any thoughts on that?
Theoretically, I think practically speaking, I'm not sure it's really going to have much of an impact on the types of cases that we bring, and I don't think there's going to be much of a mismatch. I mean, is it theoretically possible that there's a case that the criminal authorities could bring under Title 18 that we can't bring? Sure, it's theoretically possible. But I think in most cases with the criminal standard of beyond a reasonable doubt, I think there's probably personal benefit there. And even if, they don't have to charge it, I think in most cases we'll be able to find it. And especially since the Supreme Court Salmon decision, personal benefit hasn't been as much of an issue for us. So I think most of the time we'll be in a position to bring charges alongside the criminal authorities, even if they look a little bit different.
Okay, let's try to get to some of these questions. We have another one talking about 10b5-1 plans. It kind of takes the opposite, flips the earlier question and says, would you recommend companies require executives to use 10b5-1 plans to sell shares in this environment? And the questioner supposes that if that were the norm, the 8K trading gap bill would essentially become moot. But I guess I'll throw that to Rob or Sean, because I don't think Kate probably wants to go into that.
It's a really interesting question. I mean, I would be reluctant to do anything that would require an executive to, the executives are entitled to be compensated through stock. They're entitled to make a living. They're entitled to profit. They just have to do it properly. So you're really causing them to lock in that they can only sell under a predetermined program, thereby potentially not receiving a lot of the compensation that they bargained for coming into a company. So it is a very interesting approach. I would probably be more in favor of something like that than preventing anyone from making them cancel their selling plans. So that's a really interesting question.
Okay. Rob, maybe I'll throw you the next one. Do you expect more of a focus on the private markets and insider trading, given how much capital has been invested in private companies in the last 10 years. In some sectors, it exceeds the capital raised through the public markets. Any thoughts on that?
Yeah, I mean, that's a terrific question. It's a really sophisticated issue. I think from a very broad perspective, there would be interest in that area for the very reason the person asking the question flags, which is so much of the market has moved to the private market pre-IPO. But it is challenging by the very nature of those being private sales and negotiated. With insider trading as it works now in the public markets, there isn't really a lot of focus on the individual trader, the individual, counterparty. You could just talk about what's in the market. Once you get into private markets, you get into more issues like, what kind of agreements were reached, what was in the purchase agreement, what was in the contract. And it just gets a lot more complicated. So I think that's a great issue because so much attention has gone to the private markets, but it certainly is more complicated.
And I think too, because, the private companies aren't going to have the same disclosure obligations. You're not going to have that non-public information standard. You might just come down to basic fraud, fraud, breach of contract, something, not disclosing a material fact when you enter into a transaction.
I think that's right.
Okay. So I just wanted to mention one other case that I found really interesting. And it's a parallel case. I think the SEC case is on hold. It's against a former general counsel of Apple, you read the fact pattern and it's a fairly standard insider trading fact pattern. But in the criminal case, just a week or so ago, his attorneys at the Marino law firm filed a really hard-hitting brief in support of a motion to dismiss the indictment, basically on the grounds that insider trading law is completely judge-made, as Rob mentioned earlier, and thus it's really not appropriate for criminal prosecution at all. And as I mentioned in my next big thing, I do think you're going to see more of this from the defense bar over the next few years. People really, unless the statute is passed, but people really, especially in the criminal context, raising due process, fair notice, rule of lenity type arguments. And I do think they may get some traction in the next few years, but maybe that's just wishful thinking on my part. Any closing thoughts from everybody? Why don't we start with you, Kate, if you got one pearl of wisdom to leave us with?
Well, I think be mindful of your obligations during a pandemic. We're watching.
Sean?
Yeah, I would just say what probably people have been saying all day. For inside counsel, you just really have to be on top of your people. You're going to have so many events coming the next 6 months. You really want to stay on top of people so you don't get embroiled in one of the SEC investigations.
Rob?
I see Bruce down there looking itchy for us to finish. I'll just say,
Sorry.
I agree with the other panelists that the pandemic's really upended the normal rhythm of quarterly earnings and quarterly reports and blackout periods, and it's a time to be extra vigilant to follow those procedures.
Sorry, Bruce, I had you on you fell off my screen, so I
don't believe that for 1 second.
Sorry. Thanks to the panelists, and thank you for having us.
Hey, thank you, Russ. Great job. Our next panel is called Financial Firm Spotlight. It will begin at 3:50 Pacific. Thanks again to the panel. Terrific job. We'll be back in a few minutes. Thank you.
Thanks.
Thank you.
Thanks, everyone.